Good morning from Chennai, India, and a good afternoon to our friends from Tokyo. My name is Amrit Bhargav, and it is my privilege to moderate this session's hybrid panel discussion on when international commercial arbitration involves state entities yesterday, today, and tomorrow. Brought to you by the Asian Development Bank Institute Tokyo, the University of Oxford, the French National Center for Scientific Research, and SASTRA deemed University, India. Before moving on to introducing the panelists whose profiles are well known and already a part of the agenda for this discussion, it is my duty as a moderator to spell the contours of this discussion. The last 2 days of this international workshop has seen a wide-ranging exchange of views on the modalities of dispute resolution and arbitration in the context of the Kashagan Production Sharing Agreement, a globally debated proposition drawn from the Harvard Business School's Casebook 2013. I want to briefly touch upon the growth and flow of international commercial arbitration itself, its platform for dispute resolution, along with the dimensions of what it constitutes and means in the context of developing nations, whose metrics of understanding and practicing arbitration are still nascent. In this way, the panel discussion will cover aspects of international commercial arbitration that are relevant in its preliminary and qualifying branches: investor state dispute resolution, enforcement of foreign arbitral awards, arbitral legislations and institutions in the countries of the world, and making international commercial arbitration meaningful through reforms in legal education and connected issues that lay down the framework for connecting the dots of arbitration in the institutional context. Commercial and industrial arrangements have far-reaching and vast implications on investments and deliverables insofar as the scale of enterprise is determined. This relates to resource allocation and management, the respective rights of state parties, the beginnings of disputes, the background of parties, and the difference between rights and interests between state parties and business investor entities, since it is also a matter of legal sovereignty. In presupposing bilateral investment treaties and their crafted clauses on references to arbitration, the acceptability and binding nature of such clauses and their final outcomes respecting procedure and rulings on interpretation have been dealt with in various legal texts and commentaries that have enriched the subject on hand. However, the field relating to state entities and their role in international commercial arbitration is an exercise that involves state actors in stakeholder and investor roles arrayed as either claimants or respondents. In jurisdiction and jurisprudence, the typical issues relating to forum, the choice of law to be applied, national and global precedent, the language of respective bilateral investment treaties, and its implications on the sum and substance of arbitral proceedings, the composition and setting of the arbitral tribunal, writing of the award, and its eventual enforcement as law are already part of the academic and practical working of this subject that forms the core of this 2-day global workshop. The title of this panel discussion is interesting in the sense that it absorbs the time-tested truth that states are indeed commercial manifestations in their respective roles and are parties holding commercial interests in projects, especially those in the energy sector. In that vein, the role of each state now as parties before an arbitral tribunal is its sovereign interest as a commercial entity with its juristic personality as such projected before an arbitral tribunal. As a matter of information drawn from the facts before us, We are not getting into the much traversed realm of state-state arbitrations where national governments in sovereign capacity contest claims before tribunals, but primarily those of the International Center for Settlement of Investment Disputes, ICSID 1966 variety. It is notable that Dr. Kamal Hussain, in his essay on international arbitrations in oil and gas disputes in Asia, referred to a set of Latin American investor state dispute settlement arbitration and draws from the global experience where a production sharing agreement was terminated for commercial reasons by the government of Bangladesh. These developments point to an already existing anomaly for a lack of uniformity in the administration of the ISDS mandate and the broader debate about arbitration and its one size fit all obsession. On the larger plane of observation, we find that geopolitical interests have dictated national governments getting into BITs with respective countries, especially on the subject of enforcement of awards, which has raised a lot of debates in the global paradigm on international commercial arbitration. Aaron Brox, the noted Dutch legal scholar, who was the guiding star of the ICSID convention, said that the purpose of the convention was the promotion of private foreign investment, and the convention itself uses the term private international investment. He said in his 1972 lecture that for the purposes of the convention, a mixed economy company or a government owned corporation should not be disqualified as a national of another contracting state unless it is acting as an agent for the government or discharging essential government functions. With all of this, we have our panelists today who will now speak on various subjects that are involved. As we see, it is a vast canvas and there are various issues that encompass this debate before us. And we intended this panel discussion to be a context raiser for international commercial arbitration, especially on investor dispute settlement. And it is my pleasant duty to hand over the microphone to Mr. Ganesh Chandru, who will speak on arbitral institutions throughout the world and legislations thereof.
Good morning. Thank you, Amrit, for that kind introduction. It's indeed a privilege to be here. Thanks to SASTRA Law School, to ADBI, University of Oxford, and all the other organizers for putting together this hybrid, panel. Of course, I think there have been various sessions which have been going on from yesterday on dispute resolution in industrial project involving state parties. I think there was a focus on investment arbitration from the angle of the investor, that is the state, as well as the private party. I think there were two sessions, yesterday and today, on those. What we thought we'll do in this session before my co-panelists go on to specifics is to lay out a broad framework of what one needs to look at when you arbitrate. And this particular session is on commercial arbitration. First, I was asking the organizers the mix of the participants, are they arbitration practitioners or young lawyers or students? And I'm given to understand it's a mix of quite a lot of those young practitioners, as well as our friends from Japan who are hearing this online. So in terms of arbitral legislations worldwide, I think before going into that, it's extremely important to understand what is international commercial arbitration. We're talking about international commercial arbitration. How is it different from a domestic arbitration? Since we are all here in India, I thought we'll look at the definition in the Indian Arbitration Act of what is an international commercial arbitration, which is quite similar, not exactly the same, but quite similar across the world, at least to those countries which follow the UNCITRAL model law. I'll be coming to UNCITRAL model law in a minute. Essentially, international commercial arbitration is where there is one of the parties which is not in India. As simple as that. So, but the definition in our act, in the Indian Act in 2(1)(f), specifically gives the circumstances or the categories. It says if an individual who's, before that, very important to note that it is an arbitration relating to disputes arising out of legal relationship, whether contractual or not. So it could also be, arising from, let's say, there's a tortious action and you could, and there's an agreement and you could, start an arbitration, not just contractual, but mostly it's contractual. And it has to be commercial under the law enforced in India, in the Indian context. So then it is a commercial arbitration. And when is it becoming international? Is when one of the individual is a national or habitual resident of a country other than India, or the party is a body corporate, that is a company which is incorporated in any other country other than India, or it's an association or body of individuals whose central management and control is exercised in any other country other than India. This central management definition is still kept in Indian legislation, but there are certain legislation which don't look at central management. As long as the place of business is in that country, they don't classify it as international. So we still look at central management. And the other party is a government of a foreign country. So these are those categories that is given in our Indian legislation to categorize what would be an international commercial arbitration. So that is extremely important for us to understand, because here the topic is about international commercial arbitration involving state entities. So now domestic arbitration is not defined in our Act. Only international commercial arbitration is defined. What our Act, in the Indian Arbitration Act throughout says, is those arbitrations that are not international commercial arbitration. So colloquially we call it the domestic arbitration. So when it comes to arbitration legislations worldwide, I think, I'm sure many of you might have heard of UNCITRAL, which is a specialized organ of the United Nations. It's United Nations Commission on International Trade Law. It is headquartered in Vienna and it has other offices as well. And it has come up with various model laws. Model, as you know, is something for you to follow. So it's not cast in stone. You can adopt it. You can make some changes. And so it has come up with model law, for example, e-commerce. It came up with a model of international commercial arbitration. So it has propounded the model law on international commercial arbitration was first, propounded in 1985. Yeah? And that is the model law which most countries that have adopted follow. There were some tweaks and updates in 2006 to the model law, and there are quite a number of countries which have adopted that as well. And what is the advantage of this model? If you look at this model, there's harmony. You're harmonizing legislations across countries so that when you go to country A, which is a model law country, most of the provisions are quite similar. But obviously there are amendments, or where you don't adopt it in toto. There are tweaks that you make, requirements based on the requirements of a particular jurisdiction. In fact, till date, I think about almost 95 countries have adopted this. And states within countries, I think there are about 125 jurisdictions which have adopted the UNCITRAL model law. But that's only one part of the world. There's the other part of the world which has not adopted the model law. But whether or not, there is a country adopts the model law or not in its legislation, arbitral legislation, the idea of it, please understand, it is a procedural law at the end of the day. So when we say, oh, I'm specializing in arbitration, you don't say I'm specializing in civil procedure code, right? So arbitration act or the legislation is actually procedural, but it's not entirely procedural as well, because there are certain substantive issues that arise out of it. That's why this practice area is very interesting. For those who want to specialize in this area, I can tell you it's an amazing area which raises interesting issues. Sometimes there could be private international law issues. There could be, a different law governing the contracts that one would need to deal with. Not just Indian law. You could have, for example, an arbitration seated here where English law is the governing law of the contract. And you could have an arbitration in London or Singapore where Indian law is the governing law of the contract. So essentially what you do in an international arbitration is both the parties as well as the arbitral tribunal look at the rights of the parties based on the law governing the dispute, the contract basically, right? So let's say it's Indian law, you would look at the Indian Contract Act, or let's say other legislations that would apply to decide which party is right or which party is wrong. why would you look at the arbitral legislation? You would look at what is the procedure that is to be followed. The arbitral legislation would typically deal with right from the arbitration agreement. In arbitration agreement has to be in writing as per model law, and what is writing and all those is defined in the legislation. Then it deals with interim measures of protection, because even if you fight a case and by the end of the day you get an award and let's say the subject matter of the dispute is dissipated, the asset is gone, there's no point. So you need to get an interim measure to protect that subject matter of the dispute. And then it'll deal with how an arbitration is commenced, appointment of arbitrators, jurisdiction of the tribunal, how the proceedings are conducted, pleadings, what do you file, statement of claim, defense, and then evidence. Evidence, for example, in India, there's a specific provision, and so is it in Singapore and other countries which have followed the similar provisions, where the Evidence Act of India is not applicable to arbitration proceedings. Even CPC is not applicable to arbitration proceedings. But the arbitrator has to look at the weight of the evidence and give the award. But that said, we have a Supreme Court judgment which says that though it's not per se applicable, the principles enshrined in the Evidence Act and the CPC can be taken as guide by the arbitrator. This would also deal with what is an award. An award is nothing but a judgment given by the arbitrator. It's called an award. And the award has to deal with every issue, and including costs and interests. And the Act provides for that as well. Most of the legislation would provide. And then most importantly, how would you enforce this award at the end of the day? And what is your recourse against this award? Can you file an application to set aside? Can you appeal against the award? There are very few countries which have appeal on a question of law. For example, England has that provision. We don't have per se appeal provision. We can only file an application to set aside under section 34, which is very similar to article 34 of the model law. On very limited grounds, you can file an application to set aside an award. But when it comes to domestic arbitration, we have a ground called patent illegality on which we can challenge the award. And that is in a way a backdoor entry to anything and everything. But that said, we have amended our act in 2015, and the definition is extremely tight of public policy and patent illegality. So it's not like before where anything and everything you can just go to court and try and set it aside. I know I've got very little time, maybe about 2 more minutes, in which I will say that while these legislations around the world, both model law as well as not model law, obviously cover all these aspects, it is very interesting because we have a lot of friends from abroad here. So it's important for me to tell you that there are very interesting amendments made to the Indian Act, because hitherto Indian arbitration legislation was criticized to a great extent because of certain judgments made by court and on interpretations given on the time taken for the arbitral process. I think there are some excellent amendments that have been made in 2015, 2019, and a very small amendment in 2021. These amendments clarify, for example, an Indian court can give interim measure of protection for an arbitration which is seated outside India as long as the subject matter is within the jurisdiction of the court. The process of appointment of arbitrators has been made very smooth. In fact, independence and impartiality of arbitrators is spelt out specifically in Schedule 5, where you need to disclose. And the IBA guidelines on conflict of interest in international arbitration is encompassed in our legislation under Schedule 5 and Schedule 7. Hearings are to be conducted on an efficient manner. And I think, as I told you, you can't just go and challenge the award and say there is a stay of enforcement. There's no automatic stay. You will have to file an application. Court needs to consider it, and while considering it, it can ask you to deposit maybe a certain percentage of the award in favor of the award creditor. Most important amendment in my view as an arbitration practitioner, I think that has changed the way arbitration is done in this country, is the introduction of a time limit for arbitrations, especially, of course, this applies to domestic arbitration. And in terms of international arbitration, the tribunal needs to endeavor to follow this timeline. So the timeline given is 12 months from the close of pleadings. And for pleadings, you have 6 months. So you're looking at 6 plus 12, which is 18 months, within which typically an award is to be made. And parties can, by consent, extend it up to 6 months. So you can extend 1 month, 2 months, or up to 6 months. Beyond that, or if there is no consent, you will have to go to court if you need an extension. And of course, courts do grant extensions when it is, quite good reason, but it's not a given that they will definitely, kind of give it to you. Very quickly, just half a minute, Amrit, I will wrap up. In terms of arbitral institutions, I don't think I'm going to, tell much about it, because there are several institutions across the world. Like there's ICC, International Court of Arbitration in Paris, headquartered in Paris, established in 1923. There's LCIA, London Court of International Arbitration. There is American Arbitration Association and its international arm, International Center for Dispute Resolution. The most popular center with Indian parties has been the Singapore International Arbitration Center. And in India as well, we have very good arbitral institutions. Of course, they are up and coming. We have the Nani Palkiwala Center, which is in Chennai. And the government of India has passed a legislation under the India International Arbitration Act, where there's an India International Arbitration Center that is set up, and it's been declared as an institution of national importance. So institutional arbitration is something which is coming up in a big way across the world, and there are various advantages of having an institutional arbitration as opposed to ad hoc arbitration. In fact, in Japan, Japan Commercial Arbitration Association is a very progressive institution. In fact, they have adopted in their legislation the 2006 model law as well, which came into force on 1st of April this year. So with that, I think I've just given a framework, because whatever arbitration you're doing, you need to look at the place of arbitration and what arbitral legislation applies to you. And if it's an institution, you'll have to carefully read the rules and see what are those rules that would be helpful to you. For example, you need an emergency arbitrator order or an expedited procedure. All that is provided there. With that, I hand over back to Amrit.
Thank you, Mr. Ganesh Chandru, for giving us a bird's eye view of arbitral institutions and arbitral legislations across the world. So, may I now invite Ms. Shama Loya to air her views on international investment treaty arbitration.
Hi everyone, thank you to the organizing committee for inviting me to Chennai. The weather is really warm, but thank you for the warm hospitality. Before I delve into investment treaty arbitration, I just wanted to touch upon the topic on international commercial arbitration involving state entities. Ganesh very helpfully explained what international commercial arbitration is under the Indian Arbitration Act. But when we talk about involving state entities and international commercial arbitration, it essentially means one private party that is either incorporated or controlled from outside India, and an Indian state entity, which can include ministers, ministries, government agencies, departments, divisions, and even commercial companies which are owned or controlled by the government of India, and that exercise either governmental functions or commercial functions. So those are international commercial arbitrations involving state entities. Now, why are we discussing this as a separate topic? Why is it not international commercial arbitration in general? But that's because whenever a state entity is involved in a commercial arbitration, suddenly several peculiarities come to life, right from the stage of formation of a contract to the stage of enforcement of the award. What are these peculiarities? As soon as a state entity is involved, what do we need to know? What are the unique challenges that we face when a state entity is involved? Several of them, and I'll maybe highlight just 6 or 7. When a state entity is involved, you basically can have standard form contracts, which often contain one-sided arbitration clauses. You can either have a clause that says that the state entity shall have a unilateral right to appoint a sole arbitrator, or you can have clauses which say that a government employee would be an arbitrator. These are some standard form contracts you will find. Second, when a state entity is involved, you'll generally face some issue with securing documents. Mostly there will be less written correspondence involved between the parties, or records will be maintained at the office of the state entity. You also face problems with securing witnesses, because whenever a state entity is involved, the relevant people generally get transferred. So at the relevant time, whoever is in charge of a particular function may not be available when the arbitration is initiated. And then there will be challenges with respect to the arbitration proceedings, because a lot of approvals are involved. There's no clear authority for instruction. So a lot of time is involved. There could be inefficiencies and post-award challenges. Again, when I say post-award challenges, we all know that the government is the largest litigator in the country. And that applies even to post-award challenges to set aside the award. Ganesh mentioned there's no right to appeal, but then there's just another name to challenge to the award. When a government entity is involved, there are public resources involved. So, the consequences are deeper and wider. So it is generally considered as a default mechanism when there is an award against a state entity. The approach of the state entity is to challenge the award, albeit on restricted grounds under the Arbitration Act. But yes, we do still try and fit in things under patent illegality, which applies to domestic arbitration and seated in India. Why are we talking about these peculiarities? Because as practitioners, we need to work backwards and address those challenges when we are drafting contracts or when we are involved in arbitration proceedings involving state entities. So if you're lawyers who represent a private party, then some of these peculiarities we need to address. I mentioned firstly about standard form contracts and the right to unilateral appointment to an arbitrator, which state entities generally exercise. Now we have judgments from the Supreme Court. We have Perkins, and then we have Avital from the Delhi High Court, which say that such unilateral appointment clauses are not enforceable. So we need to know some of these judgments. Ganesh also mentioned, Section 12 of the Arbitration Act, and now we have Schedule 7, which lists out grounds where an arbitrator or a proposed arbitrator will become ineligible to be appointed as an arbitrator. So if you have a government employee which the state entity is trying to appoint as an arbitrator, that's squarely falls within the first para of Schedule 7. If we are aware of the law and these challenges, then we can even navigate standard form contracts, which are peculiar to contracts with state entities. With respect to securing documents, there are procedures under soft laws that apply to international commercial arbitrations, where we can secure discovery of documents, production of documents. So even if the records are maintained at the office of the state entity, you have procedures which you can use to compel the state entity to produce those documents. With respect to securing witnesses, you have provisions under the Arbitration Act. You have Section 27, where you can approach the court for assistance to compel a witness to give testimony in arbitration proceedings. So, even if it's a transferable job, the relevant person who was in charge of the action at the time cannot really say that I'm no longer in charge of that function. So, witnesses can be compelled to appear before the arbitral tribunal. These are some aspects we need to be aware of as practitioners who represent a private party. If we are practitioners representing a state entity, and I've had the chance to represent both sides, so I can tell that generally state entities are not very well versed with procedures that are unique to international commercial arbitrations. So as their lawyers or as their future lawyers, we need to make them aware of uniqueness of international commercial arbitrations, advocacy styles. I mentioned about production. I we also use Redfern schedules to compel parties to produce relevant and material documents. There are soft laws. So, as advisors to the state entities, we need to make them aware of these procedures. And we also need to dispel certain myths about arbitration. We all know about the recent guidelines that have come in just last week, where, arbitration has been restricted in respect of government procurement contracts in a domestic context to disputes that are valued less than 10 crores. Although the guidelines say that state entities should not challenge awards, and only where there is a genuine merit or a high chance of success in winning the challenge, state entities should challenge the award. But in practice, we see that that does not happen. So as lawyers, we also have a task when we are advising a state entity to consider or reconsider their approach or default approach to just challenge the award, because post-award as well, we have provisions where interest can be imposed on the state entity. So if the challenge is dismissed, ultimately we don't just pay the arbitral award amount, but we also end up paying the post-award interest, which can run into several crores. So these are certain peculiarities we need to be aware of when we are looking at an international commercial arbitration involving state entities. I can now address investment treaty arbitration and what is the interplay with international commercial arbitration when state entities are involved. When there is a contract between a private party and a state entity that refers parties to arbitration, then generally you would initiate arbitration or commercial arbitration under the contract. But there's also another remedy of investment treaty arbitration. As soon as you're dealing with a state entity, you can consider certain thresholds if you want to explore the remedy of treaty arbitration. What are these thresholds? One, whether there is an investment treaty between the home country of the private party and the government of India. And these are cumulative thresholds. These are, they need to be applied in parallel. Second, we need to consider whether the contract that is in question qualifies as an investment under the investment treaty, so as to invoke that treaty. Third and most important, relating to state entities, we need to see whether the actions of the state entity involved can be attributed to the government of India. What do I mean by attribution? Basically, can the government of India be held responsible for actions of the state entity? And we can run a semester course on this, so I'll not get into attribution. And then comes majorly the interplay between commercial arbitration and treaty arbitration. This happens in three instances. One, where the treaty contains an umbrella clause, where basically all commitments that a private party has with the state entity get elevated to the level of a treaty breach and fall under treaty protection. Second is when there are certain circumstances that arise after a commercial arbitration has been invoked. So in those cases, treaty arbitration can be initiated. And third is where an investor in a private party can invoke a treaty between the country of the investor and the government of India. Amrit, how much time do I have to look into these? Okay, so let me just focus on the second and third scenarios where there is an interplay between commercial arbitration and treaty arbitration. Let us consider a scenario where we have a commercial arbitration award. A private entity has won a commercial arbitration against the state entity and has an award in its favor. After a commercial arbitration award, can a treaty arbitration be initiated? Yes, and let me explain with an example or maybe two key examples um, involving India. First is the case of White Industries Australia versus Coal India Limited. And we are looking at international commercial arbitration in major industrial projects, right? So, White Industries was a project where uh, an Australian company, White Industries, entered into an agreement with Coalfield Services, which is a subsidiary of Coal India Limited, owned and controlled by the government of India, to develop a coal mine. The contract involved production of coal and meeting a certain target. Now, White Industries initiated a dispute against Coal India, saying that we had met the target and we were entitled to certain bonuses under the contract. On the other hand, Coal India said that one, the quality of coal that was produced was not up to the mark under the contract, and two, you have not met the target, and hence under the contract, Coal India is entitled to obtaining or imposing certain penalties on White Industries. Now, this dispute went into arbitration. White Industries invoked commercial arbitration before the ICC and won the arbitration. Now, when it tried to enforce the commercial arbitration award in India, it took nearly 9 years, running from pillar to post, from Calcutta to Bangalore to the Supreme Court. And basically, White Industries could not effectively enforce the award that it had in its favor. So, the lawyers of White Industries were extremely innovative. They thought of invoking the treaty between India and Australia and looking at these circumstances where the award was pending enforcement for really 9 years before Indian courts. White Industries said that the government of India had failed or had denied justice to White Industries. And in fact, under the India Australia BIT, the government had promised that it will not deny justice to White Industries. And this very fact of pendency of the award enforcement meant denial of justice under the India Australia BIT. What was also interesting was that the most favored nation clause in the India Australia BIT was used to pick up a clause on effective assertion of claims under the India Kuwait BIT. And this is slightly complex, but these two treaty protections were used by White Industries to basically try and enforce the commercial arbitration award through treaty means. Now, the treaty tribunal said that this is not denial of justice. Yes, 9 years is a very long time, but it's very fact sensitive. It's very peculiar to the particular country and the judiciary before whom you're trying to enforce the award. But this is definitely, a denial of effective assertion of claims and therefore awarded damages to White Industries. So this is just one example of how commercial arbitration or post-commercial arbitration circumstances can be elevated to treaty breaches. Thank you, Amrit. Does that answer your question?
Thank you, ma'am, for taking us through the very intricate web of procedure and understanding that obtains from treaty arbitrations and the interplay between domestic and global law. May I now invite Mr. Anirudh Krishnan to speak on infrastructure arbitrations.
Thank you, Amrit, and thank you to Shastra University and the organizers for inviting me to be part of this panel today. Now, when you look at international commercial arbitrations involving state entities, the one area where you would have maximum number of such arbitrations would be construction and infrastructure. So I will set out typically what these disputes relate to, what are the usual claims and counterclaims, because there are a standard set of claims and counterclaims. I would then go into the Indian scenario where I set out some of the typically problematic clauses that come up for interpretation. So that would be the broad range of topics that I would cover today. And when I deal with the clauses, I will also deal with the problematic arbitration clauses that come up. Now, typically, what are these disputes about? Now, a state entity wants to construct an airport. There is a contractor who's engaged, maybe a domestic contractor, but since we are talking about international commercial arbitrations, very often it is a foreign contractor or a consortium involving a foreign contractor and an Indian contractor. The project is supposed to be completed in 3 years. As you all know, these projects do not stick to time. So 3 years usually becomes 7 years. So what happens to the losses that accrue because of this delay? Right? There are losses that accrue to both sides, both to the state employer and to the contractor. To the contractor, because they originally contemplated deployment of men and machinery for a period of 4 years. That 3 years is the example that I gave. That 3 years has now become 7 years, and therefore they need to pay labor costs, they need to pay higher charges on equipment, etc. Further, they could have used the same labor and equipment in some other project, had this project completed in 3 years, to earn certain profits. So usually there is always a delay damages claim which is made by the contractor, which would cover all these elements. So to get into further technicalities, you can get into what are referred to as prolongation costs and disruption costs, but I think if I get into any more detail, I will possibly not be able to give you this wide range. That's for another day. Similarly, the state entity would then say that, well, we've done everything we had to do. It's you, the contractor, who's responsible for this delay. Had the airport been up and running in 3 years, we would have connected revenues. There would have been airlines that would have paid us rentals, or the airport authority would have paid us certain sums. All of this has resulted in a loss to us. And usually these contracts will have a liquidated damages clause. So there would usually be a claim for delay damages by the contractor, which would be for unliquidated damages. And there would be a counterclaim by the employer state entity for liquidated damages, where they will have to essentially prove that there was some loss that was suffered. Now, the critical issues that then come up for adjudication is, first, who was responsible for the delay? And second, what was the consequence of that breach in terms of cost? Now, who is responsible for the delay is a very simple statement to make. But when you go into the reality of a complicated project, it is not simple at all. So you will have various kinds of breaches. So you may have allegations that the state entity did not hand over the land in time. Then if the design is on account of the state entity, then the design and drawings may be delayed. Similarly, the state entity will say that the contractor did not mobilize the labor and equipment in time. The state entity will say that there were defective works that were carried out by the contractor, which required rework, which was therefore a breach of the contractor. So you would have about 7-8 delay events that the contractor alleges against the state entity. You will have similarly 5-6 delay events that the state entity alleges against the contractor. And therefore, the tribunal, the arbitral tribunal, would have to go into what are the various breaches. So they will have to go into whose obligation was it that was breached. And once they decide on the breaches, they have to go into what is called causation. A causal analysis is absolutely critical in any infrastructure arbitration. Now, in many of these cases, delay does not lie only at one end. Both parties might have been in breach at certain points of time. Then how do you decide who is liable? Now, if you are arbitrating under English law, because what I'm saying would hold good for any infrastructure project in any part of the world, and there are many of them everywhere else. You would use what is called as the Malmason's approach. If you are in America, you would use what is called as the apportionment approach. So when you look at these approaches, you will see, well, can you split up? Say if you're looking at the delay in the month of June 2024, you will then see, well, these are the delay events from the contractor side, these were the delay events from the employer side during this period, and in reality, it is only the contractor's delay event that impacted the work in June, and therefore that will be on account of the contractor. The other approach, apportionment, is where you say, all right, there were breaches from both sides, broadly we will say 15 days each. So there is a level of approximation that is involved. So for this, there is a methodology called the critical path analysis, which is done, and so the critical path analysis itself can be done in 3 or 4 different ways. There is a retrospective analysis, there is a prospective analysis, and even amongst these there are 3-4 different methodologies. There is what is called as a as planned, as built methodology. There is an impacted as planned methodology. All of these are topics of extreme technicality which I may not be able to cover. I'm just giving you a broad overview. So both parties would usually lead expert evidence. The expert would, based on the data and records available, decide on which is the most appropriate method. They would analyze the delay events of both sides and then say, all right, it is this party that is responsible for the delay. So, therefore, first aspect is the breach, second aspect is the causal analysis, and third is the quantification. All right, these were the days of breach, these were the number of days of breach of the employer, these were the number of days of breach by the contractor. How much does that result in terms of money? That is the quantification. Here also very often expert evidence is led. Now, involving Indian state entities, for a very long time, they would never carry out a causal analysis. It would be a rough and ready method of apportioning delays, which resulted in contractors succeeding in most cases. But I think things are changing now. There are decisions of Indian courts that recognize the importance of this critical path analysis. And therefore, there is a lot more awareness, and state entities also have started engaging experts these days. So it's a lot more well contested. And again, I think Shama briefly referred to the lack of correspondence in these when you have disputes involving state entities. That was extremely common. It still is common in relation to a number of entities, but there are a few who have now started recognizing the importance of contemporaneous communication, because ultimately, how does the expert decide? It's based on the contemporaneous communication. How do you decide on breach? It is based on the contemporaneous communication. So, the first major head is delay damages and extension of time. The second common kind of dispute that arises is relating to price variation. Now, price variation is, all right, the project was supposed to be for 3 years, it's gone on for 7 years. The first 3 years, steel costed me X. From the 4th year onwards, the price of steel shot up. X became 1.5x. Who bears that difference? Right? Now, to some level, there is an overlap with who caused the delay. But in a scenario where delays were caused by both parties, then usually price variation is granted, because price variation is actually not compensation for delay, but it is a mechanism to ensure that inflation does not impact the contractor. So the second head that usually is there in every infrastructure arbitration, 2 minutes, is price variation. The third is extra items. So there might be certain items that have been directed by the employer, which the employer claims as part of the contract. The contractor will say it's outside the contract. So these are the broad claims from the contractor side. From the employer side, you will have the liquidated damages claim for delay. You will usually have a risk and cost claim. If they have terminated one part of the contract and awarded it to another party, they will say they will claim the differential. And you will also have some claims sometimes for defective works. Now there are many clauses that you would typically come across that you will have to get over. First is the problematic arbitration clause, where there would be this, where there's a unilateral appointment which Shama was referring to. You also have the panel appointment problem, where the state entity gives you a panel of 5, gives the contractor a panel of 5 and says, you select one from these. Supreme Court in the core judgment has upheld it, but core has now been referred to a larger bench in JSW Steel and it is being argued next month. So that's another second important problematic clause that is there in these kind of contracts. Then from other general clauses point of view, you have what is called as an exclusion clause, where the clause provides that even if the contractor is, even if the employer state entity is responsible for the delays, the contractor shall not be entitled to delay damages. Now these clauses, there are about 10 Supreme Court judgments that hold them to be enforceable and 10 that carve out exceptions of a different kind, and you have 1 or 2 that directly contradict. So therefore, this is an area that comes up in almost every arbitration involving a state entity. The other problematic clause is an accepted matter clause. There are certain clauses in the contract which are left only for the engineer in charge to decide. Now, if the engineer in charge decides, then that decision is final. It cannot go for arbitration, but you can then go to a court. Now, what is the problem that arises? There are some issues of determination by the engineer in charge that overlaps with other issues that are arbitrable. So therefore, essentially there is a possibility of the tribunal and the court deciding on the same issues simultaneously. So that is a huge problem that commonly arises. Lastly, you have the situation of time bar clauses. There are clauses which say that if you do not claim this, if there is a dispute that arises, if you do not raise a claim within 28 days, your claim stands extinguished. Now these clauses, on the face of it, would be contrary to section 28 of the Indian Contract Act and would be void. However, there are clauses which say that a claim must be notified within 28 days. If it does not provide for extinguishment of the right, then such a clause will be enforceable, and there are other consequences which follow. Like for instance, had the contractor notified the state entity of a particular issue and the state entity had carried out a contemporaneous inspection, the issue could have been resolved. But because they did not notify, the state entity could not carry out the inspection, and that evidence of that was no longer available. In such a scenario, an adverse inference would be drawn against the contractor. Therefore, these are the broad clauses that come up. I think each of these clauses would be the topic of a separate discussion, but given the timeline, I'll stop here. Thank you.
Thank you for taking us through the illustrative nitty-gritty involved in the various clauses of infrastructure contracts and their way into arbitration and how these clauses influence arbitrators and their decisions based on causal analysis. Now may I request Mr. Triyambak Kannan to talk to us on a very different subject. How do we build a culture of international commercial arbitration here, especially in terms of the global narrative, and what has to be done to achieve that?
Thank you, Amrit. A very warm good morning to all of those physically present, and good afternoon to those who are present virtually. With due apologies to my friends in Japan and France who are looking in, I will start with a very small cricketing analogy. It is always a privilege to be in Chennai and be the finisher a la Mr. MS Dhoni. I will hope to be as good as he is. So, I think we first need to start with the understanding of what is arbitration. And there is a possible misconception which is there in the early part of most people's careers, that arbitration is not litigation. Because arbitration is defined as alternate dispute resolution. So there is this presumption that people start with that if I do arbitration, I don't need to know litigation. The truth couldn't be farther from that. You have to know litigation to understand how arbitration works. Because, and Ganesh very rightly put it, arbitration, the law of arbitration in India is a combination of substantive and procedural law. The most basic substantive law that it deals with is the law relating to contract. Because, as all of the panelists have pointed out, almost every arbitral dispute worth its salt is a dispute that arises out of commerce. A commercial transaction, a commercial understanding, a commercial arrangement, a commercial contract. So therefore, to be a person who has competency in arbitration, you fundamentally have to know contractual law very well. And contractual law is not merely the Indian Contract Act. The great advantage which we have as someone practicing in India is that Indian contract law borrows, does not lift, but borrows extensively from common law in England, in the United Kingdom. While some of the principles which apply there may not apply here, there are very many other principles that do. So therefore, when you look at issues of calculation of damages, when you look at issues of order of performance, priorities of performance, reciprocal obligations, the ability to not just look at the Indian Act, but to look at the law in England, but to look at the law in Australia, for example, which is also a Commonwealth country, or today greatly look at the law in Singapore, because Singapore is today one of the path-breaking nations when it comes to defining and redefining the law on arbitration, given its weight as being a favored arbitral nation. In terms of how is the award to be challenged, what are the principles that we will look at an award. The great advantage, therefore, as an arbitral practitioner is you have the opportunity to broad base your understanding and not limit yourself only to what is there in India. Now, therefore, this comes immediately with an extremely important responsibility on the part of an arbitral practitioner, which is you can't shoot from your hip. You can't say this is generally what the premise is. If you are relying on a principle, so for example, as Shama was saying, the white industries lawyer couldn't have simply said, let's just take a punt at making this a treaty arbitration. There has to be some degree of understanding of seeing, can I do this? Or is this going to fall flat on my face? So, therefore, if you're looking at building a practice in arbitration, then what you're looking at is building a practice in being a litigator with a diverse set of understandings of various commercial aspects of law. You're not looking at just merely filing a statement of claim towards a claim of compensation or damages and getting to that end point. How are you getting to that end point? What are the means that you're using to getting to that end point? Every case may not need an expert witness. But when an expert witness does come, you need to know how to deal with that expert witness. I've, in my experience, done matters of construction arbitrations where we didn't need an expert witness. There are times, though, where, notwithstanding advisory, clients choose not to engage an expert witness for reasons that may be theirs. How do you then still put forth your case? These are all aspects which you will learn, fundamentally only if you understand litigation. Because Ganesh put it very nicely. The Arbitration Act in India, which also draws from the UNCITRAL model law and uses the same phrase, says the provisions of CPC and evidence do not apply. That is not to say that there is no procedure or no evidence. There is certainly procedure. If you go to an institution today, every institution, be it SEAC, be it the ICC, be it the LCIA, be it even the Mumbai or Delhi International Arbitration Centers, they have their own set of rules. What are these rules? These rules are merely the procedure. So once you have this procedure, you need to then understand how it applies to your case. For example, in SIAC, a notice invoking arbitration is to be sent. Everyone assumes, oh, that is a Section 21 notice. It's not. It's a little more detailed. You have to have a little more material contained in that. You just can't simply say, I'm starting the arbitration, which you do under Section 21 here. You have to set out what are my what is the basic underlying of the contract, what is the basic ground of the dispute, and what is the basic reason we're coming to the tribunal. You don't have to set out in great detail, but that basic understanding has to be there. How different is that from what happens in the ICC? So these are all small aspects that you will understand when you start doing the practice more. And which is why, just to very quickly touch on another point, while there is a great emphasis to push the law of arbitration be taught in college, and I think it certainly must, it's important also not to introduce the subject too early. Because unless your fundamentals, your first principles, as all of our seniors who we have learned from will say, unless your first principles are sound, you won't understand what you're trying to do in an arbitration or what is being taught in arbitration. I can speak from experience. When I was learning arbitration in college, I never understood the concept of how can you go to a court and get interim relief before the arbitration starts. It made no sense to me because everyone starts by saying arbitration is alternate dispute resolution, you don't go to court, it's separate, it's outside. But you have the power under Section 9 or emergency arbitration proceedings in institutions to get relief before the tribunal starts, before even the dispute starts. How does that logically make sense? You will understand that only first if you know how interim injunctions work, for which you need to know some part of CPC. You will then understand that only if you understand what is a cause of action, because your Section 9 relief is premised on that cause of action. You won't understand a cause of action unless you know some part of CPC. So therefore, it's important, certainly important to learn arbitration, but it can't be one of those things that is taught in the first year or the second year. It has to be something that is taught once you've understood your basic tenets of law. And then it is a structure on which you can build. So, arbitration is not non-litigation, it is litigation. But it's a very different form of litigation where the advocacy is different, the style is different. You're not making a constitutional argument, so you're not arguing towards morals or principles which are not there. As Anirudh clearly said, and as Shama also pointed out, you're arguing on correspondence. You're arguing on letters. You're arguing on letters that are there or arguing on letters that are not there. So therefore, you're reading things to a tribunal saying, here it is and here it not. This is all I need you to make a decision on. I don't need you to make a decision on something that is esoteric, that is not before you, or on something that is going to apply to a larger section of the population. You're looking purely at creating the response to a dispute of papers before you. And therefore, when you're looking to create that aspect as an arbitrator, you're looking to become better commercial lawyers. So if I had to very quickly sum up, how do you build an international practice in arbitration? You build it by being better commercial lawyers. You build it by being well-rounded lawyers who have distinct understandings of commercial law. And then, as the phrase always goes, just by sheer dint of hard work. Thank you so much.
Thank you for giving us that insight into what it means to inculcate the legal discipline in bringing professionalism in the way arbitration is run in this part of the world. So before we take questions from the chat box, I would want to get each of our panelists in on their views on the whole subject. So starting with Mr. Ganesh Chandra, who spoke about arbitral institutions and laws across the world, probably 2 points that could also be addressed. One, what does it take for a lawyer from, say, a country like India to have the global mindset in approaching international commercial arbitration itself, especially when there are so many legislations, so many centers across the world? Is there a skill set that presupposes this? And second, on what you spoke about of setting aside arbitral awards, how does this work when the award is a product of a multilateral treaty?
Yeah, thanks. I think you did finish with a helicopter shot. Well done. But I hope I didn't open like our openers yesterday. Which is, fortunately we won the match. But anyway, that's on cricket. But coming back to the first part of your question, Amrit, as to what skill sets that one would require, I think what Trayambak did say very clearly that it's important to have an experience of litigation. It's very important, especially in India, because though arbitration is akin to litigation in a private setting, you do go to court for interim measures, you go to court for appointment of arbitrators where parties can't agree and it's not an institutional arbitration. You also go to court for recourse against award, you go to court for enforcement. So you need to know litigation. But how do you develop this skill set for an international kind of arbitration when there are so many different legislations that you might be dealing with and different institutions? I think the starting point for young lawyers or youngsters is, there are training programs. I think it's extremely important. Chartered Institute of Arbitrators is one of the best global training institutes. It's headquartered in London. We have an India branch as well. In fact, Shama's colleague Nusrat kind of plays a very important role in the CIAB India branch. And we all do training programs as well for Chartered Institute. And there are 3 levels of training. So first you become an associate, then you become a member, and then you become a fellow of the Chartered Institute. And very experienced arbitrators, of course, become chartered arbitrators. There are a lot of courses that go on, and Amrit, that's a very good starting point. So there's an entry course which is a 2-day course, which will give you a flavor of what is both domestic and international arbitration. And when you attend the course in India, it is taught from the Indian context, which is extremely important. That would be a very good starting point to go through that training. You might have done arbitration as a subject in your law school, perhaps, but this will give you a flavor of what international arbitration is. And you can also do similar courses in, let's say, take a short flight to Singapore and do those courses which are conducted by the Singapore Institute of Arbitrators, which is also a very good training institute. So I think the first thing is very important is you have to be trained to be able to say that you are good. One is, of course, in practice. You follow a junior, senior, and you practice that. But then I think these programs are very structured and they are very short courses that you can do. And the second part of setting aside arbitral awards, I think it depends upon jurisdiction based. It depends on which jurisdiction you go to for these kind of setting aside applications. I think courts in India nowadays are very slow to go and set aside an award unless it is a flagrant violation. Most if it's public policy, it has to shock the conscience of the court. But what can shock a judge in one country may not shock the conscience of a judge in another because of the way the upbringing of that particular, the level of jurisprudence of that country is. So, but we are dealing mostly with countries which are, doing commercial. Most of our, I think, Indian arbitrations that go outside are typically seated in Singapore, London, Paris. Maybe some in New York, and very rarely, in addition to these, I would suppose. So I think there is a lot of uniformity. So I think we can expect that courts would be very slow unless, any of those conditions under Article 34 of the model law, which we follow here under Section 34 as well. That is one aspect of setting aside. More important when it comes to arbitral awards is when it is a foreign award coming into India, for example, or any other country, the equivalent of Article 5 of the New York Convention, where you resist enforcement on certain grounds which are very similar to the Article 34 grounds. That is very, very important because no point in you having an award and you going and trying to enforce it. I think there was an example given of the White Industries case where it was so difficult and they were very innovative to later on go through the investment treaty route and and then get a decision against the host country. So therefore, I think my view, Amrit, is it's not going to be very easy to just set aside awards like it was like maybe 15, 20 years ago.
Thank you, sir. So there is a question from Dr. K. Sitaram from the ADBI. And can I ask the webmaster to open the chat box, please? It is on what happens when the government changes, but the arbitration has to continue. A change of government entails a change of policy in many ways. And what happens then? What happens to an arbitral award which is already there? And if examples of where it has been complied, even though the government changes. So probably Ms. Kshama Loya can take that.
Not a specific example, but this happens mostly in treaty arbitrations. And in fact, I will give a specific example of what happened in Vodafone dispute where there was a treaty arbitration. First litigation proceedings where the government of India imposed taxes, capital gains tax on Vodafone. I won't get into the commercial and the technical transaction and whether that capital gains tax was correct or not. But Vodafone appealed the imposition of tax by the income tax department straight up to the Supreme Court. Supreme Court said the imposition of tax was faulty and that tax should not have been imposed on Vodafone. What the Parliament did was amended the Income Tax Act retrospectively so that it could impose capital gains tax on Vodafone. Now you have a Supreme Court judgment in favor of Vodafone, but the government has retrospectively changed the law so as to make Vodafone liable to pay that tax. What Vodafone did was initiate treaty arbitration under the India-Netherlands BIT. The decision of the BIT tribunal was in favor of Vodafone and the government changed when the decision came. The government honored that award. Wanted to, actually initially the government did challenge the award before the Dutch courts, but later on settled the matter with Vodafone under the Vivad Se Vishwas scheme. So the question here is what happens when the government changes and the policy changes, and does the government honor the award or not? It's very government specific. I have just given an example where the government tried to settle the matter with Vodafone. Initial default act was to challenge the award, but ultimately the government settled it. It could have been different. The government could have just proceeded to very fiercely challenge that award and take it to a level where liability would effectively be imposed on Vodafone. So this is just one example, Mr. Sitaram. We can really not tell how the government will approach these disputes. It is very specific, and if very specific to the dispute, very specific to the liability involved, very specific to how much the exchequer, the public exchequer, is going to gain out of that particular dispute. I just gave an example of Vodafone, but I'm immediately reminded of another case of Antrix Davis, right, where the government had to fulfill, or ISRO, let's say commercial arm of the government of India, and ISRO had to fulfill a commercial arbitration award that was given in favor of Davis by the ICC tribunal. But what happened even with our current government, who, while it honored the Vodafone award through a settlement, the same government tried to amend the Arbitration Act to say that there would be no automatic stay on enforcement as soon as a challenge is filed before the court, there would not be an automatic stay. There will be a stay on enforcement of the award if it is procured by fraud. And ultimately the government of India, the current government, filed proceedings before the NCLT to say that Devas Multimedia was incorporated for fraudulent purpose of gaining the contract with ISRO. Went all the way to the NCLAT and the Supreme Court, and the Supreme Court said yes, Devas was incorporated for fraudulent purposes. So our current government did try to circumvent enforcement of that commercial arbitration award by amending the Arbitration Act and filing these insolvency proceedings. Just two diverse examples I have given you of the current government.
Thank you for taking those questions. And now, based on what Mr. Anirudh Krishnan was telling us, an almost a clinical examination of how contracts look like and what goes into arbitration ultimately, there are a lot of standard items which are part of construction arbitrations like you spoke about. Are there prefixed set of criteria that you match, like there is a BOQ and all of that? How do you approach all of those things? I mean, does it vary from country to country? Are there specifications that are different for constructions across the world?
So you have some level of standardization with the various FIDIC books these days. So by and large now, at least for projects that are funded by international institutions, you usually have one of the FIDIC books that are applicable, and therefore there is some level of standardization. But in addition to the FIDIC books, there will be a reference to there would be certain amendments and tweaks that are made, and that's where the problems come in. And these can at times be unique to the place, and there are challenges that also come from the applicable law. So some of the, on the former, that is the tweaks that are there. I mentioned some of the typical Indian examples. You will not find an exclusion clause in too many of the international contracts. But if you do, how you deal with it would depend on the applicable law. So I mentioned that in India, there are divergence of views. So in England as well, originally there used to be the rule of fundamental breach. And if it's a fundamental breach was the exclusion to an exclusion clause. But then the House of Lords then declared that the rule of fundamental breach was in fact wrong law. Thereafter, there were statutory amendments. The Unfair Contracts Term Act was brought in, and so to some extent there are restrictions, but not an absolute restriction in relation to exclusion clauses. Similarly, if you were to come across a similar clause in an American contract, you had the doctrine of active interference. Therefore, while these clauses are there in pretty much every Indian contract involving a public sector undertaking, these are rarer in the international context, but not completely absent. And how you would deal with them would then depend on applicable law. Similarly, if the applicable law is civil law, then doctrine of precedent is virtually not applicable. Whereas if it's common law, obviously the doctrine of precedent would apply. So these are factors that would influence every arbitration. But that said, when you look at construction and infrastructure, I think 80% of the determination or adjudication would be factual, where the approach would be the same everywhere. The other place where you have differences is that the level of records that are maintained. India, we have records that are minimal. Now things are improving. But if you take on, say, we did one construction arbitration in Turkey, where the daily progress reports were maintained with such level of accuracy that we had one full shelf of only daily progress reports to analyze. So obviously the level of detail also differs based on the jurisdiction and the practices followed there. Again, Africa, you would find minimal data that is maintained. So those are the kind of changes that are there, but 80% of the approach, which would be factual, would be the same.
Thank you for taking that question. There is a question from one of our participants on the chat box, and I'd request Mr. Trembak Kannan to take it. If there are any contractual ambiguities which lead to conflicts, are probably the question should be how do you resolve it, or is there a way of anticipating a dispute and negotiating the contract beforehand based on that?
So, so there are 2-3 ways to look at this. As a litigator, we all dwell in badly drafted contracts. Most of us won't have work if there are well drafted contracts, truth be told. So, the issue is this. If you ask any mergers and acquisition lawyer, they will tell you the reason they do not do litigation is because fundamentally they are averse to conflict. And which is why they work in a space of mergers and acquisitions where they bring people together. But even in that space, what is important to realize is it's very rarely that two parties of equal standing or equal position come together. I would say it's 10% of the time where two equal parties come together, and 90% of the time there is a party who is stronger placed and there is a party who's weaker placed. Now, in most contract negotiations, therefore, it's a function of who's willing to let go of what. Is the stronger party willing to let go of a position so that they have the ability to contract with the weaker party? Or is the weaker party willing to forego the risk that may come simply because they can tie up with the stronger party? So therefore, when you're looking at contract drafting, when you're looking at avoiding risks, what you are actually looking at is apportionment of commercial risk. You're looking at how much of this is a commercial risk I'm willing to let go, how much of this is a commercial risk I'm not willing to let go. And then the third factor that comes in is the innovation of lawyers. Howsoever the commercial risk may be bad, is the lawyer innovative enough to find a way out of it? Of course, that's from the contract perspective. From outside of the contract perspective, today you have the mediation bill, you have what Shama spoke about, the statement that has come from the government with regard to commercial disputes, where one of the things they have said, while they've said insofar as procurement contracts limit the scope of arbitrations, the other thing they have extensively pushed on is the need to mediate. So one of the ways obviously to avoid litigation is to mediate, to see is there the way possible to not litigate but find a solution. However, then there is still the mindset of the government where they are more reluctant to mediate given other factors that they are worried about. But these are some of the things which do come to mind.
So if there's I don't think more time to take detailed questions. So probably I would like to say a few words by way of conclusion. First, by thanking all our distinguished panelists for the time that they have taken on a weekday here in Chennai, India, for coming to the SASTRA University Chennai campus for this panel discussion touching on various subjects, multidimensional as they were. And I would only like to echo what William Lands and Richard Posner wrote in 1979, that a court system produces two types of service. One is dispute resolution, determining whether a rule has been violated. The other is rule formulation, creating rules of law as a byproduct of the dispute settlement process. When a court resolves a dispute, its resolution, especially if embodied in a written opinion, provides information regarding the likely outcome of similar disputes in the future. I think this is the truth of arbitral systems across the world, that investors, especially for commercial reasons and for business reasons, need to know the likelihood of disputes and the likelihood of them getting resolved. And if at all there is a pattern, of course, based on facts that are uniquely suited to each situation, like the Kashugan production sharing agreement that we have been deliberating for the last 2 days. And with that, I would hand over the floor back to Natia and her team in Tokyo.